Welcome back to our show. Don't worry, we are here. Before the commercial break earlier, we had received one question from our viewer, Ahmad, who is a lecturer in one of the public university. He is not happy with the three new regulation of Malay Unity Regulation under the Bumiputra Academic Act 2018. Therefore, we are here today to answer the question of whether the three new regulation of Malay Unity Regulation are valid. Now, to open the discussion today, I would like to give the definition of subsidiary legislation. Subsidiary legislation is a legislation made by the administrator in pursuance of the power delegated to it by the legislator. Section 3 of the Interpretation Act 1948-1967 defines subsidiary legislation as to any proclamation, rule, regulation, order, notification, bylaw, or other instrument made under any act, enactment, ordinance, or other lawful authority and having legislative effect. It was stated under Section 25 of the Interpretation Act, subsidiary legislation shall be deemed to be made under the Act under which it has been made. For example, the Public Officer Conduct and Discipline Municipal Council of Province Wesley, Regulation 1995 is a subset of Local Government Act 1976, while the parent act of Rule of Court 2012 is Court of Adjudicated Act 1964. Now let us move on to the question of what substantive ultra vires. Substantive ultra vires is based on the principle that legislative power belong to the parliament. It means no other bodies or agencies have power to legislate unless it is conferred by parliament to do so. In other words, the delegated law is legal if the bodies and or agencies thus empowered to legislate stay within the bounds of the authority. There are three substantive ultra vires that are related to the situation today, which are ultra vires the Federal Constitution, ultra vires the Parent Act, and implied ultra vires. Now, I would like to ask our first panelist, Prof. Emeritus Tan Sri Dr. Umar Mahfuz. Can you explain about the ground of substantive ultra vires in respect of the Federal Constitution, especially with regard to fundamental liberties in Article 8?
Thank you, Mr. Akmal. Now let's see this subsidiary legislation from a federal constitution perspective, namely under Article 8, which talks about equality. Before we move on, we must first understand that per Article 4, Clause 1, it states that the federal constitution is the supreme law of the land, which means that it can trample over our currently discussed subsidiary legislation. And there are two grounds that we can find under Article 8, particularly in Clause 1, which has absence of privilege, and Clause 2, which says that there's a policy of non-discrimination. We can refer to the case of Sri Ram Krishna Dalmia against Justice S.R. Tendulkar, where per this Indian case, there are two tests that can be applied in order to see whether a law is actually discriminatory or not. The first is for the classification is founded on an intelligible differential which distinguishes persons that are grouped together from others left out of the group. The second test is whether the law is differentiate, has a rational relation to the object sought to be achieved by the law in question.
Thank you, Professor Umar, for your vast explanation just now. Now I would like to ask Mr. Hakif. Can you explain other interesting ground about the subset violating the Parent Act?
Thank you, Mr. Akmal and Professor Umar. Now, with regard to the ground of subsidiary legislation ultra vires the Parent Act, at the outset, I would like to begin with Section 23 of the Interpretation Act, which provides that any subsidiary legislation which is inconsistent with an Act of Parliament, including an Act under which it is made, shall be void to the extent of inconsistency. This means that the subsidiary legislation cannot be enacted in contravention of the Act of Parliament, including the Parent Act. This is strengthened by Section 87, Paragraph D of the Interpretation Act, which provides that no subsidiary legislation made under either any Act of Parliament or state enactment shall be inconsistent with that respective Act of Parliament and state enactment. This can be illustrated in the case of Mai and Victoria Jayasili Martin, where in this case the respondent was refused from being a Syari'i lawyer due to the Rule 10 of Kaedah-Kaedah Program Syari'i 1993. The issue is whether Rule 10 of Kaedah-Kaedah Program Syari'i was ultra vires the Administration of Islamic Law Act, which is the parent statute. The majority of the court held that it is not ultra vires. However, we would like to highlight the minority judgment in this case, where it was held that Rule 10 is obviously in violation of its parent statute, since it has exceeded the limit imposed by the Act and it has no bearing on the purpose of the Act itself. Suryadi Halim Omar held that by referring to the case of Panko Holding, the term ultra vires can be understood in two ways. First, that the rule or regulation in issue deal with a subject that is outside the scope of the legislative authority assigned to it. Second, even though the subsidiary legislation in issue deal with the appropriate topic, it has gone beyond the bounds set by the parent act.
Thank you, Mr. Hakif, for the explanation of the law in regard to subsidy violating the Parent Act. Now, before we move on to the next topic, which is the implied ultra vires, I would like to give the meaning of it first. Implied ultra vires mean the subsidy made is still considered as ultra vires, although it followed the prescribed procedure and made within the powers conferred on the authority, making it on the ground of extended ultra vires. There are three implied ultra vires in regard to the situation faced by Mr. Ahmad, which are financial levy, unreasonableness, and improper purpose. Therefore, I would like to pass the floor to Professor Umar as what it means by ultra vires on the ground of financial levy.
Thank you, Mr. Hakif and Mr. Akmal. Now, to understand what imposition of financial obligation means, we must first understand the general rule, which is that financial levy cannot be imposed through administrative regulations under the general power to make regulations, except when the Parent Act itself confers powers to do so. In other words, this means that a general grant of power does not warrant imposition of a financial levy through subsidiary legislations. And this is even backed by our local statutes, as you can see, Section 44 and Section 17A of the Malaysian Interpretation Act. And in the case of Attorney General against Wilkes United Dairies, the Parent Act gave the power to make a subsidiary legislation regulating the manufacture, production, consumption, distribution, and sale of purchase of dairy products such as milk or yogurt. However, the food controller then issued an order that no one shall deal in milk business without license, and the appellants were granted a license on a condition that financial levy were to be paid on each milk purchase. So the issue at the courts was that whether the controller could impose the levy without being authorized to do so by the regulation. It was held that the court invalidated the financial levy as the Parent Act did not authorize the food controller to charge such levy. And a local case to back this up is the case of Palm Oil Research and Development Board Malaysia against Premium Vegetable Oils Sendirian Berhad, where it was held that a well-settled principle that a provision in a statute conferring power on a member of the executive to enact subsidiary legislation must be construed strictly, particularly where the subsidiary legislation is one that imposes a financial levy. And this is the quotation given by Gopal Sri Ram. He states that imposing a tax by means of subsidiary legislation on a person not identified in the Parent Act produces an absurd and unjust result and therefore does not promote its purpose or object.
Thank you, Professor Umar, for your explanation just now. Mr. Hakif, as Professor Umar had explained about the financial levy, what do you think on the ground of unreasonableness?
Thank you, Mr. Akmal. The next ground is unreasonableness, where this is a subjective test as described in the case of Brunswick Corporation and Stewart, where Williams J. stated that a bylaw must not be unreasonable in the sense that it must not involve such oppressive interference with the rights of those who are subject to it as to find no justification in the minds of reasonable men. Therefore, the question to be asked is whether the relevant legislation can find justification in the minds of reasonable men. There are two approaches under this ground. There is the common law approach and the India approach, where the difference is that the India approach will use a equality provision in the constitution to strike down unreasonable subsidiary legislation. The common law approach can be illustrated in the case of Cruz and Johnson, where the bylaw that required people to stop playing music or singing within 50 yards of a dwelling house was held as valid and reasonable as it does not discriminate between people. The principle in this case is where Lord Russell stated that the subsidiary will be found to be unreasonable if, for instance, it was partial and unequal, manifestly unjust, disclosed bad faith, and involve oppressive interference with the rights of those subjects as to find no justification in the minds of reasonable men. The Indian approach can be illustrated in the case of A. India and Nargesh Mirza, where a rule that any a hostess shall required upon their first pregnancy after marriage was held as invalid by the Supreme Court as it was unreasonable, unfair and unequal, which violated Article 14 of the Indian Constitution that is equivalent to Article 8 of our Federal Constitution. Fazal Ali J. held that the rule is unreasonable and arbitrary provision which is extremely detestable and abhorrent to the notion of civilized society and exhibit the quality of unfairness and naked despotism and is therefore violate Article 14 of the Indian Constitution with regard to equality.
Pardon me, but if I may to interrupt, I would also like to add on about improper purpose. Now, the general rule here for this type is that all subsidiary legislation must be used for the purposes intended by the legislature. An interesting quotation is from Gibson CJ from the case of R against Tuhi, that it must be anomalous if a regulation which bore the semblance of propriety will remain valid, even though it should be shown in fact to be made for an authorized purpose. Now, the first case that I would like to present is the case of Bank of Malacca against the Treasury, where the majority in the Supreme Court held that the treasurers singling out the appellant bank alone and not others through its order under CTA 2008 was not right in law. Lord Sumption held that the subsidiary legislation had no rational connection with the objective of the statute to frustrate Iran's weapon program. It is not necessary to eliminate the Bank Malak, which is an Iranian bank, business in London, since the problem is not specific to Bank Malak. The main takeaway from this case is that there should be always a rational connection between the subsidiary legislation and statutory objective. Now, the second case is a Malaysian case, which is Ghazali against Public Prosecutor 1964, where the licensing board attached the condition that only a Malay driver should be employed to drive in the taxi. Section 118 of the RTO states that the licensing board should give preference to Malay in exercising their discretion. Thus, Ong J held that nothing in the statute authorized the board to issue condition that only Malays are exclusively entitled. Since the licensing board is not authorized to make such condition, the statutory instrument has no rational connection with the statutory objective. It was used for the purpose unintended by the legislature and also is ultra-vires towards the Parent Act.
Thank you, Mr. Haki, for the explanation in regard to unreasonableness. And Prof. Umar for your explanation of improper purpose. Now let us back to our problem today. There are three impugnant regulations that need to be analysed today. These regulations are Malay Unity Regulation and were made under the Bumiputra Academic Act 2018. Hence, let us answer the first question, that is whether Regulation 2 and 3 ultra-vires the Article 8 of the Federal Constitution. First, referring to the case of Sri Ramakrishna Dalmia and others, first test that must be fulfilled is whether there is classification on intelligible differential which distinguishes persons that are grouped together from others left out of the group. In Regulation 2, the classification of only Malays and Malays that are affiliated to the ruling political party prove that there are distinctions made based on race and political influence. For example, a person from Indian community or Malay in the opposition party. While in Regulation 3, the classification that only Malay academics must contribute 0.1% monthly pay to the Malay Unity Fund distinguishes Malay academic and non-academics. Therefore, there are classification on intelligible differential which distinguishes persons that are grouped together from others left out of the group. Next test is whether the classification is reasonable and permissible under Article 8.2 of the Federal Constitution and relationship with the object of the law. In Regulation 2, we can say that it is unreasonable due to non-rational of relationship between the purpose of Parent Act with the heavy discrimination ground of race and political influence provided in the regulation. This is same goes with the Regulation 3, as it deemed unreasonable classification because the Malay Unity Fund seems not exclusive to the Malay academic, circle only. Thus, no relationship with the purpose of the Act to review and investigate the challenges of Malay academic. Hence, Regulation 2 and 3 ultra-vires the Article 8 of the Federal Constitution. Next, I would like to ask Mr. Hakif, do the regulation violate the Parent Act?
Thank you, Mr. Akmal. The issue here is whether Regulation 1, 2 and 3 will ultra-vires its parent act, that is the Bumiputra Academics Act 2018. To answer the question, we need to bear in mind that the power vested by the Parent Act is only to review and investigate problem faced by the Malay academic. Therefore, it is submitted that by applying the case of Mike and Victoria, Regulation 1, in that the minister has an absolute discretion to decide regarding the ethnic background of any person, is ultra-vires the Bumiputera Academic Act, because the power vested in the PA was only limited to the Malay academics. Hence, power to review any person had acted beyond the power, as it can cover beyond the Malay academic. Secondly, Regulation 2, that only Malay who are affiliated to the ruling political party could be appointed as the VC in the public university, and Regulation 3, that each Malay academic must contribute 0.1% of their monthly pay to the Malay Unity Fund, are ultra-vires on the ground that it goes beyond the scope of the Act to investigate and review problems faced by the Malay academic, as it involves the power of appointment and imposing financial burden. All of these grounds may be substantiated by the implied ultra-vires that might overlap with the reasoning given in this section that we should discuss later.
Thank you, Mr. Hakif. As we talked about the implied ultra-vires earlier, my question to you, Prof. Umar, are the regulation ultra-vires on the ground of financial levy and unreasonableness?
Now let's answer the third issue, which is whether the imposition of financial levy is permissible. In answering this, we must understand that the only regulation related is the third regulation, which states that each Malay academic must contribute 0.1% of their monthly pay to the Malay Unity Fund. And this regulation is, of course, when we apply, we will find ultra-vires under three grounds. The first is because we see that the Parent Act, which is the Bumiputera Academic Act 2018, does not confer specific power to the executive to impose fees or charges. Instead, only empowers the minister to make regulations related for purposes of investigating and reviewing problems faced by Malay academics. Now, the second ground is when we apply the first case, where we see that the financial levy is actually invalid, as the Parent Act did not authorize the minister to power such levy. And finally, the third ground is when we apply the second case and Gopal Sri Ram's quotation, where we understand that the imposition of this financial levy will, of course, result in an absurd and unjust for Malay academics, as well as it not promoting the purposes of the Parent Act. Hence, it can be understood to be an excessive delegation of power given. Moving on, let's answer the fourth issue, which is whether the first, second and third regulations were actually unreasonable. In order for us to know this, we must first ask the question on whether those relevant legislations can find justifications in the minds of a reasonable man. When we apply this to the first regulations, we can find that it is unreasonable because it is arbitrary and it is a far-reaching provision, because it is not specific to whom it is applicable, which could give room for abuse of power for the minister, as well as itself encroaching the functions of the National Registry Department in determining who is a Malay. Besides that, for the second regulation, it is unreasonable because when an appointment for a vice-chancellor is made by the political party of a government, then he will act according to the wishes of the appointed political party government and not for the benefit of the university itself. Besides that, when we impose this regulation, it will create a discrimination for those who choose to not reveal their political party favour. Moving on to the final regulation, it is unreasonable because it manifests unfairly for those who receive lower salary, which may affect their livelihood. Also, the functions of this Malay Unity Fund is not reflecting the purposes of the Parent Act, as it does not give us a hint on education for the Malay academics.
Thank you, Mr. Umar. I would like to interrupt you here to point out that other than unreasonableness, the regulation could also be ultra-vires under improper purpose. This is because if we ask the question whether the regulation have rational connection with the statutory objective intended by Parliament, that is to investigate and review problems faced by the Malay academic, we can see that the answer will be in negative. Therefore, Regulation 1, 2 and 3 will be enacted for improper purpose. For instance, Regulation 1 includes the word any person, which is very wide and goes beyond the academic circle. Thus, it goes beyond the objective of the Act, which confined only to Malay academics. In addition, Regulation 2 was enacted not to review and investigate problems faced by the Malay academic, but rather for the political purpose to appoint VC affiliated with ruling political party. Last but not least, Regulation 3 with regard to the contribution to the Malay Unity Fund seems to be beyond the academic circle, as it is unintended by the legislation which seeks to limit its application for the purpose of academic matter, and thus it's unintended to impose financial burden.
Thank you to both of you for the clarification given. Hence, we can conclude that Regulation 3 had ultra-vires the Federal Constitution, Parent Act, and all point of extended ultra-vires, while Regulation 2 ultra-vires all point except financial levy, and Regulation 1 do not ultra-vires the Federal Constitution and on the ground of financial levy, but ultra-vires other grounds stated earlier. Therefore, the three new regulations of Malay Unity Regulation are not valid. Now, I would like to thank our two experts today, Prof. Emeritus Tan Sri Dr. Umar Mahfuz and Mr. Hakif, who is public litigation lawyer. Thank you to both of you. I think that's all for today. Don't forget to watch us next week with yet another interesting topic. I am Akmal. See you next week in Don't Worry, We Are Here. Assalamualaikum.